If you can all see my screen, if my colleagues can just flag that to me, I'm ready to go.
It is
So the
visible. It is visible.
Thank you, Mila. So basically, the idea is to give you a short overview of EU equality law. I will not in detail discuss the UK law. For that, we have the expert of the Equality and Human Rights Commission, of course, here. So I don't want to step on their competence in this regard. I'm sure they're going to elaborate further on that. But what I will do is I will elaborate a bit further on algorithmic discrimination and the AI Act to give at least a short overview. So there will be 4 short parts where I will talk about the general legal framework for equality law, then something general about biases and algorithmic discrimination, basically the origins and sources of algorithmic discrimination. Then briefly, we're going to get into by design tools. Here with a little caveat that I'm a lawyer by training, so I'm not a computer scientist, so please bear that in mind. Many of you will have much more knowledge, so this is a general overview, and our colleague of the project team, Dr. Aaron Siros, unfortunately cannot be here today. He would have been much better placed to talk about by design tools. He's one of the experts on that. But I'm happy to say that we have explainers published online on the Equinet website, and along the training, we're gonna publish that, of course. So for those of you who are not experts already in AI tools, AI systems, and by design rules, please have a look at the by design explainers. And I think notably the by design explainers can be relevant for you. And then I'm going to say a few words on the AI Act that is of relevance for equality and non-discrimination law. So to start with, I wanted to show you this. Imagine that you go to your favorite search engine, for example, Google, and you type how to combine fatherhood and work. You all know how searches work. You have the autocomplete function that might suggest you something like that, what you see on the screen. Did you mean how to combine motherhood and work? But this is not exactly what this father, it's a real case, a Dutch case from 2015. He wanted to know more about how to combine fatherhood and work and not about motherhood and work. So in this example, you see quite clearly how stereotypes and biases of society are reflected in the data sets, something that you're all familiar with. So of course, we also know from a legal perspective that this as such is not a discrimination. It's problematic in terms of policy, might be not ideal, but it's not as such a case of illegal discrimination in the EU or UK law. So the question is always, when is the threshold of a discrimination actually crossed? When we do something, when we design AI systems, when we do something, when we have a law, when do we cross the threshold of discrimination? We're going to share an article with you. I elaborate a little bit on that, the distinction between direct and indirect impacts. But what is more important here in the context is to talk about biases and stereotypes. So I give you 2 more examples. If you make a picture search and you look for nurses, you typically see something like that. Nearly no men on the picture. If you look for CEOs, the picture looks a little bit like that. It's mostly men. And even though the majority might be female in the case of nurses and male in the case of CEOs, it does not reflect reality, because in continental Europe, you have approximately 8 to 9% of female CEOs. And this is, of course, a problem. We need to be aware of that when we design AI systems and when we're using them, where the problems might be, because if we are not aware, we cannot correct things. So I've done this with a prompt nurse and CEO. So now let's recall these images of the nurses, of the CEOs, and you type how to combine fatherhood and work. This is not problematic as such at first sight, but what if these data sets that show these outcomes, if these data sets that have biases and stereotypes, if they are used in an AI system, for example, in a recruitment system, then we come in a situation where it's much more probable that it can lead to a discrimination based on a protected characteristic. For example, UK EU law protects sex and gender under the framework. Then it might become problematic. So AI recruitment is a very good example where this could then play out. If you search for new talent to be recruited as a CEO and the system tries to suggest you male characteristics or male people based on previous employment history, that might become problematic. And we know all the Amazon case that was not really applied, fully rolled out in public, but it was internally tested and it showed that there are these problems. So when you design a system or use it, you need to be aware of these things. So now we take a step backward. We ask ourselves the concept of discrimination. What is actually discrimination? I'm talking more about EU law here. We distinguish generally between direct discrimination and indirect discrimination. Again, I'm simplifying here for the purposes also of not being too long, but to make things clear still, we need to do that. So a direct discrimination, for example, is a bit more easier. An example would be that an employer, let's say an AI startup, does not want to employ women or only wants to employ men. This is clearly not a neutral behavior. This is something that is based on a protected characteristic, being a woman or a man. And if this is used, it could be a direct discrimination. But there is a second way to prove a discrimination, and that is indirect discrimination. Indirect discrimination is a concept that you use when it's not crystal clear, when it's seemingly a neutral provision in a law or behavior. And that could, to illustrate that, I give the following example. Imagine that the police in a member state is recruiting, for example, in the UK, and they say in order to become a police officer in the UK, you need to be at least 1.70 meters. That is not a discrimination directly on the basis of being a woman or man, but in practice, if you compare the average heights of men and women, you have a difference. And if these statistics show you that there are much more predominantly women who are under this height threshold, then they would potentially not be eligible to the police force. And that is something that the Court of Justice of the European Union actually considered as an indirect discrimination. Of course, you need to then test whether it's justified or not. And in the specific case, it was not justified because it was not shown that you need to be of a certain height to have strengths, to exercise certain tasks. But in principle, this distinction would be indirect discrimination and is therefore not allowed. So when you have a case, when you design a system or use a system, always think about not only I use a variable man and woman or a nationality or something like that, but also how indirectly a discrimination could occur, because it's not only direct discrimination that is covered, but also indirect discrimination. This is, I think, the important basis to start. And then in the EU context, if you want to look a little bit more, here's the example of the Directive 2006/54. It's everything related to the employment, to the labor market. I'm choosing this example because my starting example was also based on the labor market AI recruitment tool. So if you have something like that, you can typically look in Directive 2006/54, who is then further defining what is a direct and indirect discrimination. But we don't need to go into the details here. Suffice to say here that an indirect discrimination can be justified. But bear in mind the two examples I gave you to make the distinction between direct and indirect discrimination. And please feel free to come back also in the Q&A section if you need further information on that. So then the question, of course, in the AI context is AI-based discrimination direct or indirect discrimination? Does it actually make a difference? Do I actually need to bother about that? There is some discussion in the literature. There's notably some researchers that you're probably all familiar with. Professor Adams Prassel and Ruben Binz and Lean Kelly-Lice, who wrote about it, directly discriminatory algorithms. They argue more for that it should be a direct discrimination. Others argue more that it should be an indirect discrimination. This is not an academic discussion here. I just wanted to draw your attention to the fact that considering we have the two concepts, we might make a choice whether it's the one or the other. Because it makes, in the end, it doesn't make a difference because both are covered under discrimination law. But in practical terms, and it's also relevant for you as designers and users of AI system, is that when you want to prove a case of discrimination, it's a little bit different for indirect discrimination because the threshold is higher. You need to kind of check the effects. You need to go a little bit deeper and find out why there is a discrimination. And then it becomes, of course, relevant. If you classify algorithmic discrimination as an indirect discrimination, then you have a little bit more to do. If you can prove that the algorithm, for example, used a variable or a protected characteristic to decide something, then it's a little bit easier if you have access to this information. We're going to come back to these evidence problems a little bit later, but just to alert you to this discussion, in the end, the practical relevance is rather in terms of evidence and proving it, not legally speaking, whether the one or the other does not fall or falls under a discrimination. Then again, on objective justification, it can be very crucial in a case of indirect discrimination because what is objective justification? It refers to the legal defense that allows differential treatment or policies that may appear discriminatory at first sight if they can be shown to serve a legitimate aim and are proportionate to achieving that aim. So as I said, a behavior at first sight prima facie could be discriminatory, but you can prove with evidence, for example, if you're an employer, you used an AI system, you can prove that that is actually not the case. And there are some justifications for it if a legislator is doing something, but the aims need to be proportionate. So there's a proportionality test as well. Then on the burden of proof, we're going to get back to that. Is then, for example, if you have a prima facie case, it could shift in the employment context to the employer. So if you want to prove a case of discrimination, it would then be in the end, if you can show some suspicion of discrimination, it would be for the employer to prove that there is no direct discrimination. But I'm coming back to that. Some further reading, if you want to dive into the EU and UK context, notably Professor Sandra Fredman and Professor Ellison Watson wrote the general frameworks where you find a lot of information, and specifically also a UK book. Oxford published a book on artificial intelligence and human rights, and there you find quite a few chapters on AI, equality, and discrimination. If you want to dive further, we're going to share the links with you as well as a follow-up. One point I wanted to raise is positive action. Positive action is something that you can use potentially to foster equality and non-discrimination. It's foreseen under EU law in the treaties, in Article 157 of the Treaty of the Function of the European Union as well, in terms of equal pay, which basically means you can positively discriminate one underrepresented group under very specific circumstances. And this is something I wanted to draw your attention to, that as users and designers of AI systems, you could think about using AI to actually support equality and non-discrimination goals by doing a sort of positive action. For example, in a recruitment tool, you could use it to allow people of an underrepresented group to go in the next round, to apply this kind of positive action in there. It's called the Rooney Rule in computer science, as some of you might know. It comes from the NFL, where there was positive discrimination attempts to allow underrepresented people to basically move to the next recruitment stage. Just that you need to be aware of that, that this could be potentially useful, because technology should not only be regulated, it can also be used. So you as tech people can make use of that. So I will not say more about the UK law context. We're going to have here something on that a little bit later by our colleagues from the Equality and Human Rights Commission. But I wanted to say, just in general, is there's a lot happening, of course, in the UK at EU level, international level. So please look also, if you're interested in the topic, look out of all the reports of the European Commission. The Council of Europe is doing some work on that for all the Council of Europe members is, of course, of a lot of importance, because it will become binding law if it's ratified in each member state. The Fundamental Rights Agency is also doing a lot of reports and studies recently, so please go out and look for those. We're going to share some of the materials afterwards. The most important act, of course, that was recently published and was published in the official journal recently is the AI Act. So I'm going to talk a little bit about the AI Act, but also to say that, as you saw on the slide, the Council of Europe also adopted on the 17th of May an AI Framework Convention. And here the difference is, and that's important for you to know as developers, the Council of Europe framework is not applicable to the private sector as such. It's only when they work on behalf of public organizations that the Council of Europe Framework Convention on AI will apply. Contrary to the AI Act applies to public and private entities. So here indiscriminately, it applies to everybody, and hence the AI Act is important for the private sector to look into. I wanted to say two more things about legislation that actually seems to not be going through. The Commission every couple of years can withdraw legislation, and one of the projects that you probably heard about is the AI Liability Directive, which could have clarified some issues in terms of liability for AI systems causing harm, for example, in the form of fundamental rights. But this AI Liability Directive has now been suggested for withdrawal, and in my view, that's a missed opportunity. Just so that you're aware of it, if you see somewhere AI liability can be helpful, be aware that this might be withdrawn. A second missed opportunity is the withdrawal of the Council directive on the implementation of equal treatment in person irrespective of religion, belief, disability, age, or sexual orientation. And this is a problem because it kind of leaves out some of the grounds covered and that are not in the area of the labor market. And so this is a very old proposal. And if this proposal would have been adopted, it would have been nice because then the extension would have been the protection on these grounds mentioned here would have been extended. And that is very good because everything that's happening in the offline world is very relevant in the online world. If it's not protected in non-discrimination law, you can also not rely on that if you're discriminated by an algorithm, obviously. So outside of the context of employment, in other areas, you would be a little bit less protected. And that's, of course, not ideal. But these 2 points, just to kind of recall that you're aware of kind of what is protected and what is not protected. So now the AI Act needs to be seen in the context of what are the rules of classical non-discrimination law and what are the specific rules of the AI Act. And from the start, I need to say that you need to think about all the general anti-discrimination directives and laws of the member states that are out there, but some are specifically relevant. If you talk about the Directive for Goods and Services 2004/113, this is of course very relevant because many services are offered in the online world. And so that's important to keep up. The other directive I mentioned is 2006/54 in the context of the labor market. Again, to say the AI Act is not about non-discrimination and equality. It indirectly protects some of the things, but it's basically product regulation, one can say, to be specific. And so you have to see these 2 things alongside classical anti-discrimination law and the specific rules of the AI Act. So going now into the AI Act, which says it's about basically fundamental, it's about internal market protection, creating innovation. But Article 1, which states the objective of the AI Act, is also about ensuring a high level of protection against for fundamental rights against the harmful effects of AI systems. So it is mentioned as an objective, and throughout the text, you're going to see something. We're not going to go into all the details, but on this overview slide, I just flagged you a few articles where the non-discrimination and equality angle becomes particularly relevant. That's, for example, Article 27 on fundamental rights impact assessments, Article 77 on the role of equality bodies or others to protect fundamental rights, what are the rights, and Article 10, for example, that foresees bias audits. Article 6 is on high-risk AI systems that, for example, everything related to the labor market, that's also highly relevant. Please feel free to ask questions and we can come back to that at any moment. There are some recitals that contain elements on equality. It's a little bit more in the recital, so not in the operative part, in the articles that are the substance of the law that you can invoke. So everything that is in the recitals is a little bit more difficult in legal terms to rely on, but courts could of course rely on it. But mainly you need to look what's in the operative part and the substantive provisions of the law. And here the things on equality are a little bit less rare. The reading guide, I'm not going to spell out, but you're going to have the slides and you can see where you find relevant provisions and recitals. But let's move on to now understanding a little bit more about AI systems and bias. And if you're a tech developer or using AI systems, you're probably familiar with what an AI system is. So I will not go into the definition here, but in legal terms, Article 3.1 defines what is an AI system. And if we talk about whether the AI Act applies or not, the first thing to check is, of course, whether you actually have an AI system. So you need to fulfill the definition of Article 3.1. And that's the definition is not entirely clear, maybe because the European Commission published just recently in February a 12-page guidance on what actually is an AI system, and it is specifying this a little bit more. So that's the go-to place for you if you want to know a little bit more when, as a company or tech developer, want to use a system or develop a system. So that's basically the definition. The legal one, there are 7 elements: machine-based system designed to operate with some autonomy, may be adaptive after deployment. It has explicit or implicit objective, and the main thing, it infers from the input it receives some output. And that can be predictions, content, recommendations, or decisions. So that's the main definition that you need to go to. And of course, there is an influence on the physical or on the virtual environment. The different types of AI, that is just a recall. I will not go into the details. Generative AI, general purpose AI models, simpler models, machine learning. Generative AI is important. We come back to that because of the context of the AI office currently elaborating codes of practice on general purpose AI systems, because they are not in the substantive parts regulated as are high-risk AI systems. They are mentioned in Article 56, but then they have specific soft law guidance that is being developed currently, that is out for public consultation. And in this, I also refer to the explainers on the understanding of AI systems, but notably also the design rules that I mentioned. These are two interesting books, if you are not familiar with them, Unmasking AI and More Than a Glitch, that are giving quite some insights if you're interested and want to have a bit more of a lighter non-legal read, but explaining some of the legal challenges as well. So one of the key things is the risk-based approach of the AI Act. I want to draw your attention to that. Basically, what the AI Act is doing is saying some things are too dangerous or unacceptable risks, they need to be prohibited. Some are of high risk, and there we foresee specific regulatory requirements, and I'm going to talk about that a little bit. And then some are of limited risk. There are just some transparency recommendations. And then there's minimal risk, where basically the AI Act is not saying a lot. That's the general distinction. So one of the things now, again, reminding that data sets used for AI systems, for example, in recruitment, we need to recall that what I said in the beginning for what we're going to discuss now. The National Standard Setting Organization of the US, the NIST, said biases remain endemic across technology processes and can lead to harmful impacts regardless of intent. And that is important. Intent, for example, is not a condition under EU non-discrimination law. You don't need to intend to discriminate. If you discriminate, it's bad enough and it's prohibited and can be sanctioned. So even if you as a developer or user, you don't want to discriminate, it doesn't really matter. And you need to be aware of that, because a lot of the things are not intentional. So probably when you design system, you have a model of the world and you simplify, but you don't really want to discriminate. And that is, I think, important to recall. And that's why we talked in the beginning about direct and indirect discrimination, because it's not only if you clearly say you treat women differently from men that it leads to discrimination, but it's also the possibility of indirect discrimination. That's why I recalled you the citation of the NIST, who came up with a great framework on managing bias and AI, if you as a developer want to rely on that. And that is in parallel to the process on the EU standards that the project is involved in as well. So what are the entry doors of AI-based discrimination? It's basically, I simplify again here for the purposes of our discussion, it can be the design of the AI system or biased datasets. So that's why it's important when you model, when you conceptualize and design an AI system, that you are aware of that it can be biased because of the people who design it. The industry is not very representative. We all know that, and everybody has their own worldviews that are reflected in the design and the conceptualization, the model of the AI system. So that's where the biases, the flaws can start. And because you make conscious choices, what variables to use, what are the characteristics that will influence the decision-making process, and that is, of course, humans are biased. Humans design the AI system, so you need to pay attention to that to reduce basically the risk of discrimination from occurring. And then the second entry door is the data sets. I mentioned that, so I can be brief. We all know data sets reflect the inequalities of society, the stereotypes, and that, of course, if data sets are used, they fuel the decision, and we need to be aware of that. There are some debiasing techniques you can do something, but of course there are some limitations. Just when you design a system, make a conscious choice what data sets you use. I know there's a lot of anarchy out there in the internet in terms of data sets, so you cannot control everything, but this is something one needs to be aware of if you want to correct it or diminish the impact. I want to concretely illustrate some of the things I just said with some examples. Austria, for example, used for the labor market service to assess whether people are likely to reintegrate into the labor market or not, and basically give funding or not. They used an algorithm for doing that. And here the problem was that they used as a variable women and their absences from the labor market. And so because of these absences, they were a little bit disadvantaged in receiving this funding. and that could have been considered a discrimination. And that's an illustration for using a variable that directly basically uses gender as a distinguishing element. You probably also heard of the Siri algorithm, where there was also a problem on race and gender in the distribution of childcare benefits. A third example is recruitment algorithms. I refer to the Amazon example, but because it was publicized, but there are others as well, when basically recruitment algorithms use data sets that are biased, that can happen in any model basically. And another example is the AMS, so that's again the the Austrian Labor Market Authority, that then used a generative AI chatbot that was helping you in your career choices. And here again, because of the data sets used, it was flawed. Women received very stereotypical answers that they should go to gender studies and the tourism industry, whereas men received more suggestions to become an engineer or deal with AI systems. That was stopped then and changed, luckily. So that's another example where basically the data sets used were influencing the decision-making process. So let me now briefly come to by design and best practices for AI development and deployment. So the by design approach is basically that you have a systematic and intentional integration of some qualities such as fairness or equality into the system's design by the start, by inception. Our principal investigator of the project, Professor Karen Young, wrote a little bit on that. Please look into this research if you're further interested and to our outcomes of the project. But basically, the underlying principle is prevention from the start. So it's not a legal choice. It can be a legal choice, but it's not. It's by design. You do it basically on your own without a legal rule being there. And now, what does equality by design mean? Equality by design now basically refers to the same thing, but you want to specifically address issues as fairness, equality, inclusivity, non-discrimination into the technological system. And that's why it's important what we heard before. You need to be aware of that. If you're not aware of that, you cannot use instruments or design in a way that is or attempts to be compliant with equality law. So that is really, really important. And by that, basically AI systems could promote equal outcomes from the start and not waiting basically for something that goes wrong and then look for something. So there are some core principles of equality by design. I already en passant mentioned them. Here again, I refer to the explainer that we published, which is a condensed form of the explainer. So please go on our Equinet website to look at that. It's about bias prevention, fairness, accessibility. So these are the things you kind of need to then reflect. There are some key steps, and this is very relevant from the perspective of equality law. Diverse design teams. I mentioned it already. If you only have a certain age group of a certain ethnic background that comes from certain universities, of course, the way AI systems are modeled is different from a situation where you have complete diversity in all respects. So please be aware of that the designing process is very inclusive. And you can do some testing in before bias audits, impact assessment, and other things to basically check whether what you plan to do is also working. And you need to monitor afterwards whether that is happening. You need to ensure that everything remains explainable and is transparent in the most possible way. I'm talking here by design approach, but the AI Act foresees some of these things, actually makes it mandatory. For example, for high-risk AI systems, you need to do some of the things. You need to do bias audits, and in some circumstances, impact assessments. So in essence, one could say, what should the tech companies do? Comprehensive risk assessment are conducted at the design stage. It's a very good recommendation. And these are, by the way, also things that are currently being developed in the standard setting process at CEN-CENELEC, the JTC 21 committee that is developing European harmonized standards to basically feed the AI Act to specify some of the requirements, notably for high-risk AI systems. So there is an incentive not only to do it now, before the rules will basically apply and oblige companies to do so. And in the UK context, one has to say, every time you do trade with the EU, you would have to apply by the rules. So it's not only restricted to the 27 member states, but basically the whole world that trades with the EU needs to comply with these things if they want to trade in the internal market. But the question is, and I was already referring to that, high-risk AI systems requirements, how is such a by design approach reflected in the AI Act? It's not really explicit, I have to say, but you can see it in some of the things we just saw, because requirements such as data governance, data quality, it's Article 10 of the AI Act, bias mitigation, Article 10 again, human oversight, all of these things are somehow contained in the AI Act as a requirement. These are all requirements that you see here for the high-risk AI systems, Article 6 and the following. And so somehow it's reflected, not directly, but indirectly. So when you follow a by design approach, it means that you might cover already some of the elements that in any case will become mandatory. So even outside the context of the AI Act, you have an interest to do these kind of things. There are some limitations, of course. It's complex to do. You should not only over-rely on technical solutions. That's why you have the law, and the AI Act foresees some of the things, and you need to constantly adapt. And in the end, my favorite point is the difficulty in measuring fairness, because when you come from computer science, you know there are at least 21 commonly accepted definitions, but much more on what fairness means. So if you use the concept of fairness when you design an AI system, at least from the perspective of an equality non-discrimination lawyer, this is somehow struggling because it's difficult to grasp. Courts cannot really do a lot with it because fairness in that sense is not a legal term when it comes to equality non-discrimination. Fairness does exist, but in a different context. And so it's very difficult to grasp it under EU law when you don't speak about equality non-discrimination as specified under EU law. And that can become a problem. So you need to be aware of that when you design your system, that you might comply by one fairness matrix, but not by the other. And then what does a court or an administration do with it? If you say, I comply by my fairness matrix, and then the court said yes, but contrary to another fairness metric, the case needs to be seen differently. So you need to be aware of that. And if you have a case of discrimination, there might be difficulties in proving it, or you just need to be equipped with the right tools and be basically ready to show that you did everything according to the book. So that's a big thing. And I think you need to be aware of that, but we don't have time to go more into that. So I want to finish with the last part, some of the AI Act and legal challenges for equality law. And I kindly ask my colleagues to step in and shout if I have only 5 minutes left or I'm over time, because I cannot see the time here in my slides. But it will not take a long time to go through the EU AI Act in the context of what are the legal challenges. So the question is always, what is important for tech companies, obviously in our context? And here I have to say that, again, that the AI Act only indirectly ensures equality. And it's important to say also that you cannot make a complaint on the basis of the AI Act for non-discrimination violations. That's not really the intention of the AI Act. You have to go to national law to do that. But there are some bridges, some connections between the two. And so it's important to know that. I was mentioning that the AI Act is basically based on an approach based on high risk of AI system mainly. That's where the most provisions are. That's the most technical regulation when we talk about high risk AI systems. Just to give you here some recent use cases to say potentially this will be very relevant in many areas. When we heard from the US, there's a lot of working surveillance software that is automating even the firing and surveillance at the workplace. So all of that would, if it comes under the EU AI Act, would be potentially and could be flagged. So it's really many companies are using these AI tools to survey and to recruit. So it's very relevant in practice. And now again, in the context of by design, I spoke about a few of the obligations. Article 6 is basically a high-risk AI system. And then Article 8 and the following specify some requirements. And I mentioned risk management system already. That's an obligation. You need to establish a risk management system. But you also need to provide data and data governance, technical documentation, record keeping, basically to understand the decision-making process. If something goes wrong afterwards, because of that, there is some room to basically access the information. And that even has advantages compared to a classical case of non-discrimination, because you have a system that records the steps. It might be difficult to understand, so you need to ensure that information is provided to understand. There needs to be transparency, maybe some humans to survey the process, but also to explain. But in principle, this information can be very useful to explain and understand why discrimination happens. And there are many more obligations of the providers, like a quality management system in Article 17, documentation keeping, again, automatic logs in Article 19. So all of these things are quite important and can be helpful also to be in compliance with the AI Act if you have been doing that in any case already, or if you follow the by design approach. So how to comply with the AI Act? I mean, first of all, you need to go into the AI Act and understand the provisions that are applying for you, but it's also important to look out what the European Commission is giving for guidelines. I mentioned the example on how to understand the definition of AI system that was published in February. Also in February was published guidance on what are the prohibitions. So that's a very long document, 110 or 20 pages, that tries to explain what falls under the prohibition of an AI system and what does not. And if you design a system, this is very important to know. You might be thinking, I'm doing that, and if this is really prohibited by the EU, you might reconsider your design choices and adapt it so that it is in line with EU law. There will be further implementing acts also at national level and further guidance coming out. So just check out the AI Office website basically in the future over the next years, because many provisions also will still take time to apply. That is interesting to follow. And then, of course, the real person, so to speak, the institutions who will provide the definitions and the interpretation will be the Court of Justice of the European Union and the national courts, of course, so you need to look out for that. Obviously, there are no cases yet on the AI Act, but in the future, that is something to look forward to, because many things are problematic and will probably be need to clarified. I said some things will take time, so the entry into force was on the 2nd of August 2024. The prohibitions.
Dear Fabian, I'm really sorry to interrupt. We're running a bit out of our time. So do you think you could wrap up in a few minutes?
I will up. Give me a minute or two and I will be done.
Thank you.
Thank you very much, Mila, for this flagging. And so there are other systems that takes a little bit more time. Just to give you one example, in 2030, if the public sector is using AI systems, they only will need to abide by the rule in 2030. So that's quite a long time from now. There are some key actors, EU AI Office, market surveillance authorities in the member states. From an equality perspective, Article 77 is quite important. We're going to share these with you. I maybe just want to finish with 3 slides on this. Information and transparency is really important, because if you build, if you are confronted as a company with a complaint by a victim of discrimination, you need to know what you need to do actually, what information you need to provide. So it's important to look into different provisions of the AI Act. For example, Article 71 is about your database. You need to publish some of the things, and that is at the same time good information for complainants. But you need to be aware of what you put in there can be used by people. There are other transparency requirements. There are some requirements also for the general purpose AI systems. I don't have to come into that. But because of the Article 86 is the right to request information, Article 85 of the AI Act, which is the right to complaint, you might need to be confronted with some of the things you need to give to complainants. And that's why we have all these information requirements, obligations in the AI Act. And you also need to look into the GDPR basically to understand what information you need to provide. Again, a lot is unclear as of yet, but it's very important how to basically get to the evidence, and there you need to know what you do. I think I will leave it at that, and I still have, but we can leave that to discussion. Two cases. One is on AI recruitment, and one is the Deliveroo case, where we can illustrate some of the things we just discussed. But I think I leave it at here and stop here with my presentation, but please feel free also to come back later with any questions that you might have.